It's the appointed time, and we have a quorum. Please invite the administration to join us. I'm going to dispense with the introduction. You have the attendance list with you. Welcome. First of all, the meeting on the 12th of January. We're doing the clause by clause. Members have expressed some concerns. Is bracket CB 2776/14 to 15 bracket 01. That's the list of follow-up actions. The administration has given us a response paper. Paper number CB bracket 2776/14 to 15 bracket 02. I believe you all have it. Let me first ask the Deputy Director of Home Affairs, Mr. Jack Chan, to take us through the paper. You can follow up with further questions if you have any afterwards. Good morning, everyone. At the meeting on the 12th of January, members have raised a number of issues. We have given a written response paper to the Secretariat and it's been given to members. I'll just go through the salient points. First, self-managed estates or as buildings. If the OC Owners Corporation decides to switch from a PMC property management company to self-management, there will be far-reaching implications. We propose to amend the BMO Building Management Ordinance Cap 344 to require such a decision be supported by the passage of a resolution at a general meeting of the OC. But we're aware of the concerns of members that there is a gap between the bill and the proposed amendments to the BMO. We are consulting the DOJ to see how we can make amendments to the bill to achieve this objective. And in relation to buildings with a lot of flats, and if they want to switch to self-manage, members have expressed concern. Our idea is that if there are more than a certain number of units in a building, we will not allow the OC to switch to self-management. We are seeking advice with the DOJ to amend the bills. We will revert to members shortly afterwards. And in relation to the mechanism for PMC to report OC's decisions, we think it's very important that the OC, PMC and owners to work together. We encourage the PMC and the owners to resolve issues through communications. But sometimes either advertently or inadvertently, OCs may ask the PMCs to do something that contravenes the bill or the code of practice. We think PMCs are professional entities, and they will know how to deal with it in an appropriate way. But if the OCs or owners insist on asking the PMCs to do something that is in contravention of the bill or the code, then PMCs can inform other owners by posting notices at conspicuous places or putting letters in owners' letter boxes so that owners may take appropriate action. We also advise PMCs to report any malpractice in owners' meetings. The code which is to be formulated will require the PMCs to report to the authority of any suspected violating acts, say for example contraventions of the requirements under the BMO, the bill, and the codes of conduct. So that the authority may take that into account if they receive any complaints against the PMC. In relation to issues raised that are related to clauses 4 and 5, well, under clause 4D, if the licensee is summoned to the authority to explain or produce certain documents, if they fail to attend without reasonable excuse, then it is an offense. We would like to expand the scope of the clause that without reasonable excuse, if the licensee fails to answer questions or offer explanations, or if they have failed to meet the requirements of the authority or the tribunal, it's also a disciplinary offense. And 5.1 empowers the authority to issue codes of conduct to provide for matters that may relate in disciplinary action. We would like to expand the scope of the clause to include issues related to disrepute. In relation to the codes of conduct to be promulgated, we think that there will be 3 sets of subsidiary legislations after the bill has been endorsed. First, in relation to the services within the different categories, the amount of levy and appeals. In relation to the subsidiary legislations related to registration, they can only be put in place after the authority has been set up. We are aware of the importance of the subsidiary legislations. We will submit information about the sub-leg as soon as possible for members to consider them. And on the codes of conduct, it will be formulated by the authority. We will draw reference from existing codes of conduct or practice of relevant professional bodies. We are now preparing the framework of these codes for the reference of the authority. Once we have the draft, we will make them available to the Bills Committee for members' reference. Thank you. Members, any follow-up questions? Mr. Chen Kin-po to be followed by Ms. Claudia Mo. 5 minutes to start with. Thank you. I'm quite concerned about the information set out from paragraphs 6 to 9, malpractices, and what the PMC can do. I think the proposed amendments are quite appropriate. There are a lot of OCs that properly manage the buildings, but from time to time we learn from the press that some OCs may make decisions that are detrimental to the interests of owners, especially when it comes to major projects or significant expenditures. A lot of it has been addressed by the amendments to the BMO, and I see that you endeavor to introduce more amendments, and you talk about criminal liability. Can you explain further to me? Well, PMCs are bound by OC's decisions, and you mentioned about making reports to the authority in paragraph 9. That there is actually a conflict. You have to decide who is in the right. I think what you try to do is to address the concern of PMCs, because they may be afraid to object to the OC's decisions just in case their contract is not renewed, or they will lodge complaints against the PMCs. It's a good thing, because they will guard against wrong decisions of the OCs. But for an owner, sometimes they will find certain decisions of the OCs unpalatable, and they will raise the issues with the PMC. Do you think current measures are sufficient? Is the only avenue the Lands Tribunal? How long will it take? Can you give us some idea about the timing, about the case being fixed for hearing, so that owners will know what to do? Well, first of all, I thank the member for his support. If the OC requires the PMC to do something inappropriate or something unreasonable, currently, well, there is a mechanism under which the PMC may report to the authority. So that in the future, if a complaint is lodged against the PMC, that report will be taken into account. We also encourage PMCs to take the initiative to make a report, not just in case of future complaints. We also encourage them to explain to other owners.
They should let owners know that the OC is making unreasonable demands. As I said, you can post up notices, you can write letters to owners, or at an owners committee meeting, you can talk about such unreasonable requests so owners can take action. Mr. Chan was asking what kind of action can be taken. According to the BMO, the owners can do certain things. 5% of owners' shares can call a meeting which can discuss the actions of the OC and possible follow-up action. They can even replace the OC. But of course, the judicial power rests with the Lands Tribunal. If an adjudication is necessary, people go to the Lands Tribunal. But the HAD also provides a series of support services, including helping owners to fight for their interests. We also provide information and free legal advice to small owners. we also have experts who can answer their questions for free. As to how we can further improve upon the legislative framework, Mr. Chan is right. We are now reviewing CAP 344, the BMO. The public consultation ended last week. We are now collating the information, and hopefully very soon we can bring back some ideas to consult you as to what improvements are possible. Ms. Claudia Mo. Very often people say the OC calls the shots, and it seems the chairman of the OC has unlimited powers. But then you say the PMC can also lodge a report against the OC. I think most people would agree with checks and balances. But the thing is, the PMC is employed or engaged by the OC. So do you think the law will be effective? Secondly, in terms of property management, the OC and PMC might then be confrontational because they will be able to report on each other. In drafting the legislation, do you think it will be extremely difficult? If you make it too easy, then there will be numerous reports all the time. But if you make it quite narrow, so people will not file reports easily, and so you do not have such a big workload, because I can expect complaints to come in droves if you make it very easy. So how are you going to draft the legislation? And number 3, small owners will be at a loss in the end because the OC or PMCs can both make reports on me. If OC and PMC join hands in a very friendly way and target small owners, then there will be very little protection for the small owners. Have you considered this point? That's the third question. Thank you. Mr. Chan. Thank you, Chairman. And Ms. Mo, for your 3 questions. Number 1, that the PMC is engaged by the OC. Whether the boss of the PMC will therefore dare not report on the OC. Well, that's exactly the objective of this amendment bill. We'd like to enhance the code of ethics of PMC by allowing them a license. If they lose their license, they will also lose their business. If there are unreasonable requests or demands, the PMC will first of all has to consider how they can keep their license. If they collude with the OC and do something illegal, then they will lose the business and also the license. And then they will not be able to operate anymore. This is how we are going to allow PMCs and their staff to do things in a careful way because they need to treasure their license. And then they can also say in no unclear terms to OCs that they cannot violate their code of practice, and also they will also lose their license. And then they will say, I'd rather lose your business instead of losing the license. Number 2, whether there will be confrontation created. We understand we need to strike a balance. Later on, when we draw up codes of practice and code of ethics, we have to be very careful with the drafting so we can have a balance. But as to frivolous or unreasonable complaints, at the consultative committee stage, we have thought about allowing the future authority to tackle proven vexatious and groundless and unreasonable complaints. The authority can then dismiss such unreasonable complaints. Because to the OCs, owners, and PMCs, etc., that in fact would be a kind of nuisance. And number 3, how we can protect the interests of small owners. When we draft the Code of Ethics and Code of Practice later, we'll have to give it very careful consideration in order to strike a balance, and we are open to your ideas. We will be very happy to take your ideas on board if you have any good ones. Mr. Chen Kin-po, second round. But let us ask Mr. Wu Chi-wai to ask questions first because this is his first round. Mr. Wu. Thank you, Chairman. 2 points. Number one, some clarification. Because I've said in a few meetings that the code of practice or code of ethics will become a form of sub-legislation, subsidiary legislation. Now you say you want to relax the drafting. Does it mean that the PMC should discharge such responsibilities under the Code of Ethics, and that is they need to comply with Cap 344 BMO and also the Deed of Mutual Covenant and the codes that can be formulated from time to time by the PMSA. Is it the way it will be? Number two, I'd like to talk about an actual example. In the DMC, well, as you know, the most common dispute is whether people can keep pets or dogs in an estate. That will be clearly written in the DMC. But very often, the OC can make decisions. Maybe they tend to be accommodating, or they just disregard the case, or they condone such practice. What is the responsibility of PMCs in such a scenario? Mr. Chen? Yes, 2 questions. Number one, the Code of Ethics. Mr. Wu, your understanding is correct. We would propose that the PMSA lists in the Code of Ethics clearly that PMCs and their staff would have to comply with Cap 344 and that they should also make sure that the OC will also comply with Cap 344 and also the codes of practice or ethics that may be made by the PMSA, as well as other ordinances governing the operation of lifts and escalators and also fire services. The situation will vary from estate to estate. If the DMC stipulates that there should not be the keeping of pets, then the PMC will have to implement it and should also urge the OC to implement the same. But if a majority of owners do not agree, then it will be best to have communication amongst the owners, PMC and OCs to get to the root of the problem. I cannot say too definitely what will happen because it will really be up to the owners, the OC and PMCs to communicate. It will be very difficult to stipulate this in words or in the law. Some follow-up? Well, yes, I understand the situation, but I was talking about the extent of responsibility for the PMC. If the DMC stipulates certain matters, then will the PMC be able to enjoy any exemption from duty? Say, for example, after they have exercised due diligence, for example, then there would be an exemption clause. As I was saying, pets will be kept or not kept in an estate, and then it would be up to the OC to interpret the DMC and allow certain owners to keep pets. But the thing is, in this way, somebody is not implementing the DMC as it is written. There may be neglect of duty on the part of some people, and so where will the responsibility lie? This is quite a common example, you know. It's a common dispute in estates. And this has something to do with the extent of responsibility for the PMC vis-à-vis the implementation of DMCs. And secondly, Mr. Chan, you can you tell me what is the time lag between the passing of the amendment bill and the subleg? Our understanding is we have to wait till the passing of the subleg before we have all the details. What's the timeline? Well, I'll ask Mr. Chan Kin-po to ask his questions, and then you can reply to Mr. Wu afterwards. Mr. Chan Kin-po, 4 minutes. Thank you. A very simple follow-up. Just now, the DD did not have the chance to explain the function of the Lands Tribunal and the cost and also the timing. I'd like to give him some time to answer the question. Yes, Chairman. The LT adopts certain procedures. We've asked the judiciary what these processes are. Our understanding is that basically the LT adopts the simplest way to discharge its work. People don't have to wait too long for a case to be heard. We don't have the exact information at hand, but our understanding is that people wait a few months. The crucial thing is for both parties to have all the information, so no time will be wasted in collecting information. So we are not very worried. And my understanding is when cases go to LT, they will usually propose mediation. So no judicial processes are necessary. As to the cost, I'm sorry, we don't have the information at hand because it really depends on the complexity of cases and what resources both parties are prepared to invest in the case. We can supply the information on cost in writing. A follow-up. I'd like to ask more questions. Maybe I can ask the question at the council meeting. It will be a written question at the council meeting. You should get the information available starting from now. Some people, when they set up OCs, they may engage in illegal acts. Maybe the OC can be set up within a month, but the case will not be heard by the LT yet. I will be asking this written question. From what I know, the government agency concerned will allow OCs to be formed within a short period of time, but then at the LT cases have to wait a few months. Mr. Chan, we are quite happy to provide a detailed paper after consulting the judiciary to let members know about the LT processes, including past cases and their timing. That would be for the reference of members. Okay, I will wait for your paper to come first. Mr. Chan Kin-po talked about the setting up of the OC and possible disputes, and that OCs can be formed before the case is heard by the LT. Okay, we will also address this point. Now, DD, can you now take up the questions asked by Mr. Wu Chi-wai? Mr. Wu? Okay, you have 4 minutes. I'll be very quick. Thank you, Chairman.
Just now, my understanding is that the authority will make a decision when a complaint is lodged to see whether it's substantiated. I'd like to ask, is there an arbitration mechanism or a mediation mechanism within the authority to help the PMC, the OC, and owners to resolve the issues? First of all, in relation to responsibility, as I said in reply to Mr. Chan Kin-po's question, in a future code of conduct, we require PMCs or practitioners to report to the authority about the OCs making unreasonable requests. PMCs may use different ways to explain the matter to owners, say for example by posting notices. And the time gap between the main legislation and the sublects, we hope that the sublects will be endorsed as soon as possible. And that's why we said in reply to members' questions that we are aware of the requests for all the legislations to be in place so that the licensing regime can be put in place. So we would like to have the sublects endorsed as soon as possible. But we are aware that these sublects are very important. We will explain to members about these sublects as soon as we can so that members can take them into consideration. But we have to wait for the authority to be set up before the codes can be put in place. So that depends on the main legislation. We think the time lag will be small because we have already have all the details of the authorities in place, and we will draft all the sublects and introduce them to and give them to the Bills Committee to have them vetted, and then these will be given to the authority for them to be formulated, for them to formulate the codes. We can't tell you the time, but it will be as soon as possible. What about my third question, the mediation? You're right. The authority will handle complaints, and one of the ways to handle complaints is through mediation. Failing that, the authority will make a decision, and there is an appeal mechanism, an appeal board for parties to make representations. Mr. Porter, 5 minutes question and answer included. I don't know if I heard Mr. Chan right. He said that if there are problems, the PMC has the duty to report the matter. I don't know if I've missed the background, but I have a question. The direction is right because you improve the regulatory regime of this sector. So, well, let's look at it this way. PMC is appointed by the board to carry out certain activities, or is it the case that other shareholders report some board members? How does it work? I think Mr. Jie has misunderstood what was said. Deputy Director, would you please explain? The legislative intent is to enhance the standard of property management services. PMCs will continue with their role to manage the building, and there is an additional role that's related to social responsibility. So they are not just employees, they are professionals, and they have to conform to codes of conduct. If they find some demands of OCs or owners unreasonable, they should not submit themselves to that, and they should advise owners against it, and failing that, they can also make a report to the authority. So the role of PMCs have been enhanced. They're not just a company engaged to manage the building. They are also a professional body. So what is the relationship? Who is the subordinate in this relationship? Of course, there is a professional role to be played by PMCs. It's just like what Mr. Wu asked about keeping dogs. Under the existing legislation, say the OC of a building, they have the right to decide whether to implement certain terms in the DMC, because there may be the power, and whether to use it and how to use it is a different matter. The PMC will play a professional role, so they may veto a decision of the OC or report an unreasonable decision of the OC. So there are different roles played by the PMC, and it may give rise to conflicts. Mr. Chan, if we are to enhance property management, owners, OCs, and PMCs will have to resolve issues through communication. That is the general principle. And in relation to the future roles of PMCs, I have already explained. They are the same as other professionals, say an accountant. You audit the account of your client. Accountants will not turn a blind eye when the client asks the accountant to do something illegal. It's not the case that the PMC will veto the OC's decision. The PMC will have to explain to other owners and to the OCs that this is improper and something has to be done. They don't have the power to veto an OC's decision, but they have the professional duty to tell them that it is inappropriate. Of course, something are clear-cut, say, for example, money laundering, where, but if something that is in a gray area, it can be done, and it may not be appropriate, but it's not against the law. But if PMCs are asked to report OCs, I think you will have to be very careful, because you can ignore the advice of a doctor or an accountant. But if you encourage them to report, it's very serious, of course, unless it's something like money laundering. We need to explore this further. Next, Mr. Kokim. This is very much related to 344. An excellent PMC will better manage the building alongside with OCs or enforce the terms of the DMC, say for example keeping of dogs. Of course, a high quality and excellent PMCs will help OCs to do that. The principle is to follow the DMC. This principle is to be followed no matter what. It's not about conflicts between PMCs and OCs. It's the relationship between the OC and the PMC. One is an employer, the other one is to carry out duties. And I think the word report is a bit heavy. You should provide information to the OC, say for example relevant legislation, requirements under the law for the OC's consideration. If the advice is ignored, then still the PMC has carried out its duties. And I think that is the essence of this bill. It should not be turned into a source of conflict. That is an opinion. And I would like to also talk about the Codes of Conduct, paragraph 0.6, 4 bracket A. It's mainly in relation to professional misconduct. Of course, there should be discussions about the formulation of these codes, and should these codes be incorporated into legislation? We agree with Mr. Ip. Whether it's codes of practice or codes of conduct, they have to be properly formulated with flexibility incorporated into them. It should not be too rigid. And it should be enforceable and regulated by the authority. It's not the case that we encourage them to make reports unless it's very serious. Of course, PMCs should perform their duties by giving OCs and owners best advice. In the end, it's for owners and OCs to make the decision. Well, the code of practice focuses on professional misconduct. Is that right? Yes. That is one of the most important areas of the codes of conduct. Professional misconduct, conduct that is not professional or dishonest. Any follow-up questions? No? Next, Ms. Ho, 5 minutes, question and answer included. Thank you. I would like to ask Mr. Chan to clarify. PMC may report, should not report, should report. Are there any would there be any information in the law under which they should make a report? Say, for example, the anti-terrorism legislation that if it involves money laundering, you will have to make a report. Of course, if the OC asks the PMC to do something illegal and the PMC is replaced, of course, it's just like a labor matter. A complaint can be lodged. If it's unreasonable dismissal, a report can be made. Mr. Chan, can you clarify? There is nowhere in the legislation that requires a PMC to make a report. If that is the case, then I have no worries. Well, what about when OCs collude with PMCs to do something that hurt the interest of small owners? Say, for example, we've seen cases when they have worked together to stop owners to look at their books.
Later on, when the amendment bill is passed, can small owners report such acts to the PMSA, or will they not be able to do so? The HAD will just send people there to make sure that there will be no physical fight, so no reports are necessary to be brought to the police. Okay, Mr. Chan, I think members are very concerned about the relationship between PMCs, OCs, and owners. Thank you. Ms. Ho, your understanding is correct. First of all, the law does not stipulate that PMCs must make a report. This will be written into the Code of Practice for their reference. If there is a complaint against the PMC, it can say, I have already made a report. So the responsibility does not lie with me. It will not be stipulated in the law. Now, can I interject here? Does it mean if somebody complains against it, does it have to resort to a report having been made as a defense? Well, no. it will just be one kind of defense. When the PMSA looks at a complaint, it will look at a basket of facts. Small owners who will be prevented from checking the account. Later on, because of this amendment bill, which will bring in a licensing system, the small owners can complain against the PMC to the PMSA, and the highest penalty will be a revocation of license. So there will be such a mechanism for small owners to make a complaint to the PMSA, which will make its adjudication, and following that there is an appeal mechanism. If the OC requires the PMC to do something, well, yes, I was here, Chairman. I heard that. And the PMC might not only have to alert the OC, it should or might have to also inform the small owners. So the PMC will not do anything illegal and affect its own license. As the DD said, it will have to depend on the actual situation on the ground. Actually, the PMC, the OC, and the small owners are in a situation together, but the PMC will have to act in a professional manner and try to minimize arguments and conflicts. And at the same time, it should be able to abide by its own code of practice and act in a professional manner. Chairman, the OC, small owners, and the PMC, I think there is a subtle check and balance relationship amongst the three. And I can imagine the OC and PMC will be able to resolve conflicts between them more easily. However, if the PMC and OC collude, then we'll have to make sure that small owners will have a recourse for complaint. Well, Mr. Chen Kin-po asked that question, and the DD has promised to follow up and consult the relevant departments, including DOJ, to see what owners can do and how much the LT can help. Because right now there may be areas which are still unclear. The DD will provide detailed information to the meeting. Yes, Chairman, I undertake to provide a detailed paper ASAP to include the processes of the LT, the time required, and the relevant costs, if I can identify those. Ms. Alice Mack. Chairman, I'd like to ask a practical question. When you draft the code of conduct, well, this is outside the jurisdiction of this committee, I understand, but there are many standalone buildings in Hong Kong with OCs. When they replace the PMC, a lot of documents or papers are lost. And even when the chairman of the OC is replaced, again, papers are lost. And this does not only involve standalone buildings. There was such an estate recently that I know of to be in the same situation. So I believe the PMC should also be required to handle properly the papers of the OC. Very often, the outgoing chairman of the OC will somehow make papers disappear without passing them on to the next chairman. So when PMCs are replaced, when the OC has a new chairman, I believe it should be up to the PMCs to keep in custody papers of the OC in a proper manner. Just now we talked about PMCs making a report against OCs, but then sometimes the OCs may have done wrong deeds, but then they are not alerted to it because they don't know. Sometimes OC office bearers may not be familiar with the law, and honestly, they don't know the amount of money involved in a project before a general meeting has to be called. And recently we have seen more cases where the PMCs are inadequate. Sometimes the PMC manager does not attend an OC general meeting. Can we write this into the code of conduct? Sometimes I have seen OCs in a very pitiful situation because they would have already awarded a contract without telling owners or without telling everything to owners, and then the OC has committed a misdeed. But the PMCs may be responsible somehow because they have not told the OCs what should be done, because even the manager does not attend OC meetings. Didi, well, what Ms. Max said is exactly a major area that we'd like to address. At the Consultative Committee, we have discussed this for long, and in the future code of practice, we will require the PMCs to discharge a series of duties. A big part of it will be proper handling and keeping of important papers and correspondence or financial information about the building it manages. And not only that, if necessary, if the OC or small owners would like to make an inquiry through a proper process, such should be submitted. And in fact, when a new PMC comes in, the outgoing one may not be willing to hand over the information, or may say that it has not kept such information, and the OCs and small owners will not know what to do. In the future code of practice, will stipulate that the PMC must keep in custody all information properly, and if it leaves the job, it will have to hand over the information to the OC or the incoming PMC within a stipulated period of time. If they don't do so, they might have their license revoked. Very often we do understand that the OCs do not want to do improper things. It's just that they lack the professional knowledge. This bill will allow PMCs to have their professional standards enhanced. Through the licensing system, PMCs have a professional responsibility to transfer professional knowledge to OCs and direct the OC's work. If it doesn't do this, again, the most serious penalty would be revocation of license. In other words, the PMCs will be required to supply such professional knowledge. And if the PMC fails to do so, the OC can complain to the PMSA. Thank you. If members have no other questions, I'll propose that we continue with clause-by-clause examination of the bill. Last time, we stopped at part 2. We should start with part 2, clause 6 today. Didi, can you now take members through the relevant clauses? I propose to do what we have always done, and that is we'll ask Mr. Kwok to take members through the clauses, and then we'll be happy to take questions. Part 2 is on prohibitions. Clause 6, prohibition of unlicensed activities and penalties are stipulated. If someone has no PMC license, he cannot act as a property management company or claim to be a licensed PMC. Bracket 2, no person may, without a PMP Tier 1 license, act as a property management practitioner, claim to be a licensed PMP Tier 1, or describe himself or herself as a registered professional property manager, because by so doing, they will break the law. And bracket 3 is about tier 2, and then bracket 4, a person convicted on indictment will be subject to a fine of $500,000 and imprisonment of 2 years, and on summary conviction to a fine at level 6, that is $100,000 and to imprisonment for 6 months. Members, any questions? Yes, Ip Kwok Him. Like to clarify, what is the difference between indictment and summary conviction? Thank you. About summary conviction, those will be heard at the magistrates' courts, but indictment, these will be heard at the district courts or the high court. Any follow-up? In what circumstance will cases go to which court? It depends on the case. If it is a serious case, can you give us examples? In what circumstance will you consider taking cases to the different levels of courts? Mr. Lam, can you give us some examples? Let me try to speak from our understanding, but later on we can supplement information. Let us look at brackets 1, 2, and 3. As our draftsman was saying, if it is a serious case, it will go to the district court. For example, there is fraud. In other words, this person has no license, but then he will be purporting to be a PMC to canvass for business. And if he does it on a regular basis, then this may amount to a serious case. Secondly, he might have sent in the application, but the license is pending, so he's still without a license. But he misunderstands that once the application is submitted, he can already act as a PMC. Then perhaps this is not such a serious offense. This is what I guess to be the difference between the two. But let us see whether you can supplement the information later. Well, I hope you will make it clear. But it will have to depend on the circumstances of every case. But I can add, when I read other ordinances, very often under prohibition, the penalties are like this. Serious cases are dealt with by indictment, and not so serious cases are dealt with by summary prosecution. But who makes the decision? When prosecution is taken, this will be a decision made by the DOJ on the basis of evidence. Maybe our legal advisor can help. Mr. Lee? Chairman, I in fact didn't want to follow up on this point. I'd like to make another point about drafting. Say 6.1. It says, no person may, without a PMC license, act as a property management company. Now, in terms of acting as a property management company, do we have to refer to clause 2, and that is in relation to a business entity? Well, we have explained that in our written submission last time. Yes, the two are identical.
My second point, 6.2 and 3, or 6.1b. That is, a claim to be a licensed PMC, describe himself as a registered professional property manager or a licensed property management officer. If that is not a fact, it's an offense. And now you use the term claim. And in 6.2 and 3, it also comes as Chinese and English. What if it's said in another language, or if a different description is used, which in effect is a professional property manager or officer? Are there any provisions to catch that as well? Thank you. We agree. We propose that we will amend the provision to prohibit anyone to use any language or any way to make the other believe that he is a license holder. Sorry, Mr. Ip, I think you have a follow-up question. Is that right? Well, I heard from Mr. Chen that there are similar prohibition provisions in other ordinances. It's for the prosecution to decide after considering the severity or the gravity and effects of the case. Level 6 fine, what is it? What is it? $100,000. Thank you. Any other questions relating to clause 6? There will be amendments, right? Yes. Let's continue. Mr. Kwok. Clause 7. There are, the exceptions to Section 6. In other words, the Hong Kong Housing Authority or an employee of the authority is excluded. And companies providing one single service, say for example, cleaning services, does not have to hold a license. A third type, OCs that manage their property on their own. 4. Owners provide property services themselves. They don't have to be licensed, but they have to be an individual, and they do not provide a property management service for profit to other buildings. And this does not prohibit a person from providing a service outside Hong Kong. And it does not apply to holder of provisional PMP Tier 1 or Tier 2 in Schedule 4. Any questions? Ms. Ho? I know that it's been covered a lot in Clause 4 about self-management. I'd like to get some clarification. If owners engage a company that provides a single service, is excluded, is that right? Because I can't imagine owners themselves taking up the cleaning work or plumbing work themselves. That's right. If an owner engage a company that provides a single service, then they don't have to obtain a license. So in relation to these single service, it has to be clearly defined. Otherwise, there may be a loophole. You will provide us with more information, is that right? You will clarify to us further about what is property management service. We had a detailed discussion in the last meeting. When we go over Schedule 1, that is classification or definition of companies, we can go over it again. Well, I'm quite familiar with recycling services. It's not widely promoted yet, but when it comes to collection of waste, separation, it's quite specialized. So when it comes to one type of service, they need to be very careful when it comes to waste collection and waste separation. It will be very difficult for them if you think they are two separate services. If it is not one type of service, you will have to get a license. Just like what Ms. Ho said, if that service is seen as two separate services, they will have to obtain a license. Yes, we are aware of that. Legal advisor. 7(1)(b). A public officer acting in that capacity, does it include other public bodies, say for example the airport authority, etc.? There is a legal definition of public officer. A decision will be made accordingly. Another thing is that it has to be managed in the capacity of a public officer before this is met. And we're talking about if it is just one single, if there is only one owner and there is no such requirement. Any other questions in relation to this clause? Let's continue. Mr. Kwok. Part 3, Clause 8. The authority is empowered to issue PMC license. Upon application, the authority may issue license of PMC license, PMP Tier 1 and Tier 2 license. And it may only be issued to a company, a partnership, or an individual carrying on a business as a sole proprietorship. And Tier 1 license and Tier 2 license may only be issued to an individual. The license is not transferable and it remains in force until the end of the period specified. And the period specified must not be longer than 36 months on which from the date when the license is issued. Any questions? Ms. Sit Ho. There are 3 types of licenses. The license will be valid for 36 months. Why draw the line there? There was a detailed discussion. 36 months is the longest period. That is, the longest period is 36 months upon first issuance or renewal. Is related to either license to a company or an individual. We have considered the need to strike a balance. We have to ensure that the validity period is not too long, otherwise it will undermine the role of the regulator, and it should not be too short because it will cause it will be quite troublesome for the licensees. If you require them to renew their license once every 6 months or a year, we struck a balance. We think the maximum period is no more than 3 years, but there are circumstances in which the authority may not issue a license lasting that long. Say, for example, for companies that have a very short history, or for particular practitioners, they have committed a minor breach in the past and they want to renew their license. The authority may want to monitor the situation, and so they will give maybe a license of 1 to 2 years instead of 3. Well, I'm not really on the side of the trade, but I have to ask this question. I don't know what is the usual length of a contract between owners and PMCs. If PMC is in the middle of the contract, and if there are problems with the license, you won't just affect the licensee, you also affect the OC as well. Have you considered that? Yes, we have. PMC contracts are usually 3 years long. There may be a situation when the license have to be renewed during the PMC contract, but there is no need to worry. If an application is made within a certain period of time before the expiry, then the license will continue. If it is granted, there will not be any gap in between. Members have asked questions about the issuance of license, say for example the number of practitioners and the services provided. Because this may be related to the eligibility. They don't want a company to be granted a license without providing adequate service or without sufficient manpower to do so. When it comes to practitioners, there are 2 tiers. Members have asked questions about the delineation of these 2 tiers. Say, for example, how many Tier 1 practitioners or Tier 2 practitioners can a PMC engage? I remember members have expressed concerns in these areas. They would like the administration to give more information on it. Thank you. In the last meeting, we had a detailed discussion. Before issuance of a license, the authority may require the applicant to provide information, say for example the number of properties under their management, the organizational chart of the company, the positions and scope of duties of the principal officers. The authority will decide who is going to get Tier 1 license and who is going to get Tier 2 who is to hold a Tier 1 license and Tier 2. A simple follow-up question. Well, there are 3 types of licenses. And say, for example, in the second year, there is a new business taken up by the PMC, say a new building. If a contract of 2 years is to be signed, it might have gone beyond the current validity period of the license. How is it going to be dealt with to ensure there is no breaking up of service? It doesn't really matter how long the contract is, as long as there is a valid license. Say, for example, the validity is 1 year and the contract is 3 years. It doesn't matter as long as the license is renewed at the expiry of the current one. And if there is change in the business of the PMC, well, we have the requirement that whenever there is significant change, say for example change in the principal officers or change in the scope of business, say for example some of the buildings are no longer under their management, they have to report to the authority. This is in relation to material change. Failing to do so will result in a revocation of the license. And there are also conditions to be met. Say, for example, such information will have to be made available on the internet.
No, the license will have a validity period of 1 year, but then they can sign contracts of 3 years. It seems they would be acting outside the law, wouldn't they? Just recently, with regard to the Columbia law, you have the license only for 1 year, so you should only be able to work for 1 year. Legally speaking, it seems the PMC will not be able to extend its license validity beyond 1 year. Is that legally proper? Well, the situation is, according to the law, if the PMC acts without a license, it's a very serious offense, and the fine can be up to $500,000, and also there may be imprisonment for 2 years. The PMC has the responsibility to get a license before it acts, or else it will be subject to penalty, and the OC can make its own decision. It should, of course, require the PMC to be licensed while the PMC goes about its work. We'll be sending out information to small owners that after the licensing system is in place, they will have to watch out which PMC to engage. And the PMC has the responsibility to renew its license, or else the contract cannot be continued. These are details which will be included in the licensing system that will be drawn up. I understand. Legal advisor, can you give us your comment? They sign contracts for 3 years. The OCs and owners will find that to be all right, but the PMCs usually only have license which are valid for 1 year. And you say that 2 months before the license expires, the PMC should apply for renewal. Can you comment on this point, legal advisor? Thank you, Chairman. The service contract is a private contract. The law does not stipulate how it is to be written, but OCs should act with caution and check the license validity period of the PMC, and the contract can be so written as to provide for validity of the contract on the basis of the PMC being licensed. And if the PMC fails to get a renewal of the license, the contract will come to a close. And if the license period will just be another 3 months, then the OC may face a higher risk. It is for the contracting parties to assess their own risk. Another point. Usually, the PMC will try their very best to seek a renewal of the license. This should not be too worrying. Can I add? We'd like to minimize disturbance, so we would say the license would normally be valid for 3 years. Mr. To? Our travel documents have to be renewed half a year before it expires. I understand the DD's view, but let us think about this. Should we just send information to the PMCs, or should we write into the Code of Conduct to require the PMCs to seek a renewal if the license will expire in another 6 months, and that it should be required to let the OCs concerned know about it before they enter into a contract? I myself would say that we should require this in the Code of Conduct, that the PMC would be required to let the OCs know when their license will expire before a contract is signed. Well, Chairman, this is more or less what we have in mind, actually. And also, all information will be uploaded onto the Internet. OCs can easily check the Internet to see whether the PMC they have chosen holds a license. It will be very convenient. But in the Code of Conduct and Code of Practice, we will require PMCs to be proactive in informing their employer or future employer when the license will expire. I think in future, PMCs may be shown to have been complained against or that they have been reprimanded. I'm sure Such information can also be found on the internet later. I can understand why members are concerned this. Yes, members are very correct. Any other questions? If not, Mr. Kwok, can you continue? Yes, Chairman. Clause 9, application for licenses. A. The application must be made to the authority in the specified form. It must contain the prescribed information and must be accompanied by the prescribed documents and the application fee. Bracket 2. The authority must not issue a license unless A. The authority is satisfied that 1. The applicant is a suitable person to hold the license, and 2. The applicant meets all the prescribed criteria for holding the license, and B. The applicant has paid the prescribed fee for the issue of the license. Now, suitable person will be interpreted or defined in Clause 11. Number 3, the authority may impose on a license those conditions, including prescribed conditions, that it considers appropriate. And 4, if the authority decides not to issue a license, it must by notice in writing given to the applicant within 21 days beginning on the date on which the decision is made, A. Notify the applicant of the decision, and B. Give reasons for the decision. Members, any questions? Members discussed this before, and they also mentioned the fee. I remember the department has certain ideas, but the figure is just for reference at this stage. Nevertheless, it is a concept that members can think about. Is it $1,500 for the manager and an officer, $700? And the company license, how much is it? You remember? I will dig up the information. As far as I remember, PMA, $2,200 for manager and $400 or $450 for an agent. As for the company license, I'll ask my colleagues to dig up the information. Well, it doesn't matter. This just gives members an idea, because we like to keep the application fee low because, as you know, eventually it will be transferred to the small owners. I remember it's about $2,500. But this is just an idea for members' reference. Yes? Ms. Ho? Is it that you are seeking to recover cost as well? And a personal license will be non-complicated as far as renewal is concerned, but for PMCs there may be complaints to deal with, etc. But why do you only allow 2 months? The same for personal licenses. I don't exactly mind the 2-month period, but can government departments work that fast, especially if the PMC concerned has to submit documents and other things? Then why do you give 2 months while you also give 2 months to PMP licenses? DD, now that we are on 10, why don't we go into that, because it is about renewal. Let me give you the figures first. The distribution will be like this. First of all, we will make an estimate as to the operating cost of the PMSA. We think it would be $30 million a year, 2/3 of which will be put together by transaction levies. All property transactions will be subject to a levy, which will be about $200 to $300. The remaining 1/3, the $10 million, that would be put up by license fees. Because we don't want to ask PMCs and PMPs to put up all the operating cost of the PMSA, because eventually it will be transferred to tenants or owners. And as for the figures, Tier 1 license, $1,200. Tier 2, $400. It would be more expensive for PMCs, $6,000 because it is a trading entity. Sorry, Ms. Ho is not coming through. Well, I think this is not proportional. 6,000 for a company, 1,200 and 400 for individuals. Well, it's all right when people are working, but what if they renew the license while they are not working? $400 will already be too much. If you compare with other cost recovery fees, I think this is on the high side. Didi? At the consultative committee stage, we discussed this thoroughly. Our message at the consultative committee is that such figures are acceptable to the trade. We are talking about managers and above, not frontline staff. We are talking about higher ranking and supervisory staff. And they told us that such fees would be affordable and reasonable. We have taken reference from licenses for other industries. We believe such fees are very reasonable. Ms. Ho? Well, there is no absolute right or wrong in this matter. It is a matter of perception. I would say that PMP Tier 2 license may be too expensive because people may not have a job when they renew the license. And compared to the company's license fees, I think the individual's fees are not proportional. I hope you will give another thought to the level of fees for individuals. Didi, later on, the levy would be stipulated in the subleg, and then we can give it more consideration then. Mr. Kwok, Clause 10. Yes, Clause 10, renewal of licenses. It says here, but this is actually quite similar to a new application. An application for the renewal of a license must be made to the authority in the specified form within 2 months before the expiry of the license, and must contain the prescribed information and must be accompanied by the prescribed documents and application fee. The authority must not renew a license unless the authority is satisfied that the applicant is a suitable person to hold the license and the applicant meets all the prescribed criteria for holding the license. And the applicant has paid the prescribed fee for the issue of the renewed license. And the authority may impose on a renewed license those conditions, including prescribed conditions that it considers appropriate. The renewed license is not transferable. The renewed license remains in force until the end of the period specified in it. The period specified under subsection 5 must not be longer than 36 months, beginning on the date on which the renewed license is issued. If the authority decides not to renew a license, it must, by notice in writing, given to the applicant within 21 days beginning of the day of the decision is made, to notify the applicant, give reasons for the decision. And the license may be renewed for more than once. Ip Kwok Him. Thank you, Chairman. First, I need some clarification. The fee for the license. You are only talking about the application fee, is that right? License fee, does it mean application fee? It would be 3 years. Is that right? Well, it's the license fee, not the application fee. So it will be annual, yes. Secondly, why is it that you ask people to renew only 2 months before the expiry of the license? You say within 2 months before the expiry. And only in that period can people apply for renewal. Why not allow them to do it earlier?
Can you give them more flexibility? We're talking about 36 months. So can they make an application, say, half a year before that? Because that is the general practice. It won't be too close to the expiry. What was your consideration? We have taken into reference other licensing regime. We think that 2 months is sufficient in processing the applications. There's more than enough time. Of course, providing that all the information is in order. It will take longer if further information are required to be furnished. There are 2 questions here. So we need to consider the stability of the practitioners. Say when it's 3 months before the expiry, there is a new client coming, but you haven't had your application for renewal dealt with yet. I don't think that is conducive in the continuous operation of the company. Yes, for others it may be 2 months. What is the disadvantage for giving them more time? It should be better. It would be better to give them more time in case you need to ask them for further information. So what is the difference between 2 months and 6 months? Is it feasible to allow 6 months? Isip's suggestion is very good and very reasonable. We will consider whether to extend it so that companies or licensees will have more time to deal with their applications. And next time we will revert to you as to how many months we will change it to if we do. Mr. Porter, there may be a large number of companies or individuals applying at the beginning. So in about 3 years' time, there will be another large number of applications made for renewal. What if an application is made less than 2 months before expiry? So are there any circumstances when you can change that to more than 2 months or less than 2 months? And I see that there is a word must here. It's must, too much of a duty when it comes to an application. I just refer to the broadcasting ordinance. Even for serious matters like a broadcasting company, the word is may. Now here you use must. So I would like to hear about the legislative intent in this regard. For professional licenses, if it is a renewal, if there are no serious matters involved, it will be renewed with no problem. And for some contract-based services, if it's, say, a restaurant, if the license is not renewed, then it can simply close. But for a property management company, it will affect a lot of different parties. So can it be the case that unless there is evidence to show that there are serious breaches committed in the past, the license will be renewed? Will you have to give them sufficient time so that the application can be made in time? I think you have to give it more consideration. I just told Mr. Ip that we will consider whether to extend the 2 months. We will take all the other factors relating to license renewal into account. When it comes to the term, I would defer to the law draftsman. 10(1)(a) must be made to the authority in the specified form. Must contain the prescribed information and must be accompanied by the prescribed documents. An application fee. The authority may by regulation prescribe these information. These prescribed documents and information will have to accompany the application for the consideration of the authority. We believe that these documents and information is necessary. If the applicant fails to provide the information, then the authority simply cannot consider the application. That's why we use the word must. That's exactly my question. If you have to furnish all the information, well, I think, well, it will be the other way around. Say for example, unless this and that is done, the authority must not issue a license. So it's very harsh. The standard is very high, like a criminal offense. One of the conditions is that the applicant is a suitable person, but there is no clear and objective definition. Does it mean that the authority will have to prove that everything is in order and there is no problem before the license is renewed or issued? I gave you an example just now. Say, for example, the communications authority, even when it comes to a broadcasting license, is not as harsh. Can you tell me, from where did you take this word? Which provision or ordinance, or is it the norm now? We will consider it to see if there is any elbow room, and we will reply to you next time. Well, it's a matter of the English term use. It seems that is not very common. Legal advisor. It is also about the timing of the application and the decision of the application. What if, in cases when longer time is required to consider the application, if it takes more than 2 months, will you specify that the license will continue to be valid until a decision is made? This is a very good suggestion. We will propose a suitable amendment. If an application is made and the decision of the authority is not yet made, then the license will continue to be valid. Legal advisor. The second point for clarification is clause 7 or subclause 7, that the authority, if decides not to renew a license, will have to, by notice in writing, give the decision to the applicant within 21 days. Well, the decision affects the owners significantly. Will it specified in the codes or subleg that the decision will have to be given to owners within 21 days because of the significant impact? You can't find another PMC in 21 days. So if the 2 months is extended, will the 21 days be extended as well? We'll take that into consideration. 21 days and 2 months are related, so we will take them into consideration together. Last question about this clause. It's related to Mr. Zhe's question. It says here that it's an application has to be made before a certain time before the expiry of the license, And in 2, it doesn't say that the authority must not deal with a license applications out of time. So if it's made out of time, is there any room for the authority to consider the application, say for example under certain circumstances? We have to carefully consider that. We would like PMCs and practitioners to take the renewal of licenses seriously. We don't see any reason why PMCs, knowing full well that the license is to be expired and they're required to make an application within a certain period of time, fail to do so. We don't want to encourage practitioners and companies to not be bothered to renew their license. They have a very important role to play, so we would like PMCs and practitioners to renew their license on time. But what about applications made out of time? Are they treated as a fresh application? Or just let their license expire? You're right, Chairman. Sometimes they may think that they will leave Hong Kong for a number of years, or they will not engage in businesses related to property management, so they will just let their license expire. But if you don't make a renewal application on time, when you want an application again after it's expired, you will have to apply for a fresh issuance. Mr. Pauze, second round, 4 minutes. It's something related to me, because we're talking about a trade that will be regulated, and they have never been regulated before. I think it should not be too rigid. 2 months and then 21 days notification period. If an OC wants to call for an emergency meeting to appoint another company to manage the property, I think they will be subject to unnecessary pressure. There will be more technical difficulties to overcome, and it will give rise to grievance. You need to give them more than 2 months to give them more flexibility. For the 21-day notification period, you need to allow for occasions when a transitional arrangement is needed. Say, for example, for the provisional license to be extended to deal with urgent matters. Say, for example, change of companies. And now the way it's written is very rigid. It's like rocket science. It may sound like something good, but I think it will be to your disadvantage. There will be problems with actual regulation and enforcement. Please consider whether there is any actual need to make it so rigid. Give them more discretion to deal with early application out of time, applications with a retrospective effect.
DD will follow up. Next one, Ms. Sitho. Thank you, Chair. Indeed, with regard to renewal by PMCs, 2 months and then 21 days, I think there will not be enough time. I hope you will consider allowing them more than 2 months before expiry so they can apply for renewal. Especially with borderline companies, say those that have been complained against, if they want to deal with those at an earlier time, they will not be able to do so if they are just given 2 months, and this will be unfair to them. I hope you will go back and amend this clause, especially for PMCs. Secondly, PMP licenses. The legal advisor has a point. Some people man or woman, they may have a baby, so they want to stop 3 or 4 years and to take care of the child, and then when the child goes to school they can take up their job again. However, the license fee is by no means inexpensive. If you ask them always to have a valid license, or else they will have to reapply, I think that is not ideal. Even for your driver's license, you can stop for a period of time, and then you still do not have to go through an examination to apply for the license. It's just that you can always apply. You just have to pay up the license fee for those years you did not apply for a license. You must prepare for situations where people want to suspend their career for the sake of a newborn child. As long as it is not unreasonable period of time, you should allow them to reapply without going through the application procedures. In fact, I have already answered the question when we answered Mr. Paul Chair. We already said that we would give it a serious consideration. We believe there is room for maneuver vis-a-vis the 2 months. It will be good actually for both the applicant and the PMSA. As for suspension of someone's career and the license, I believe there should be such a mechanism. When the PMSA is set up, we believe it will react to circumstances. We'll have to see why PMPs have suspended their licenses. Now, if they have had their licenses cancelled, now by losing their qualification or on other grounds, of course we have to take it seriously. But if it is an individual's decision, I believe it will be treated with leniency. As long as the academic qualification remains valid, we will not make it too burdensome. It is only when people have been the subject of irregularities or have had the licenses cancelled, then we will have to view that seriously. Well, Chairman, people don't lose their academic qualification or work experience. These things don't disappear. But of course, if it is found that your certificate has been bought or you have had ghost writers helping you with your examination, unless it is a misrepresentation or deception, then you lose your academic qualification. But in fact, our concern is about qualified or eligible PMPs who would like to suspend their career for some time. Maybe their finances are so good they can afford to rest for a while, and then after maybe a financial turmoil, these people have to work again, then they would apply for the license again. But as to the intervening period of time, we can discuss that. If someone has left the industry for 8 years, 10 years, and is no longer familiar with the industry, then yes, we can understand why you want them to sit the examination again. But if it's just for 3 to 4 years because of a newborn child, or because of emigration, or because they don't think they need the money, then if it is not a very long period of time, you should allow them to just apply again. I hope you will allow a rather suitable period of time for these people. Okay, DD, can you consider that? A new application and renewal should be treated differently. This is what we are saying. Some people may be late in renewing their licenses. They don't apply before the expiry of the license for renewal. And we are asking you to apply a grace period and also consider the length of that grace period. Yes, we agree with the direction of this proposal. We will consider the implementation details and the period of the grace period. We will try to include this in the code of practice for the PMSA. And that is within a certain period of time, the application would be regarded as renewal and not new application. Chairman, this is why we want to look at the codes of practice before we endorse the legislation. They can give a lot of promises today, but those promises can go down the drain if they just come back and say the PMSA does not agree. So I hope the codes of practice, at least the outline of the codes of practice, can be shown us before we pass the legislation. Because you are telling us today a lot of the details would go into the codes of practice. Well, DD, we're all very concerned about the major codes of practice and the sub-leg. We would like at least to know the outline of those documents. Well, yes, I have already promised at the outset of this meeting that the sub-leg and codes of practice would be submitted to the committee once they are ready. No, not once they are ready. We are saying before the passing of the main legislation. I think he has heard you. We have a little time, but I don't think we should get on with more clause-by-clause examination, because we are just 2 or 3 minutes before the scheduled ending of this meeting. I would propose that we adjourn here, and I hope that members' views expressed at the meeting and information sought. I hope the DD, since you have given the undertaking, I hope you will submit written replies to us. The best thing is to submit them before the next meeting, so our discussion at the meeting would be more meaningful and efficient. The next meeting is scheduled for the 27th of February, a Friday, at 10:45 in the morning in room 2. If there are no other matters under AOB, the meeting is adjourned here. Thank you very much.